Everyone, this is Dhananjay Sharma and you are watching World Legal Help Organization. In today's video, we will discuss a very important topic under the Civil Procedure Code 1908, and that is decree. According to Section 2, Subclause 2 of the Civil Procedure Code, the term decree has been defined as decree means a formal expression of an adjudication, which, as regards to court expressing it, conclusively determines the rights of the parties with regard to all or any of the matter in controversy in a suit, and which may be either preliminary or final. So this is the definition of decree which has been provided under the code. Now, breaking down this definition of decree and carving out the essential elements of decree, the first element is decree is a formal expression of an adjudication. What is adjudication? Adjudication implies a judicial determination of a matter in dispute. So only when a judge has applied his mind in a proceeding or in a dispute, only then it amounts to an adjudication. So a decision on a matter of administrative nature will not amount to an adjudication because judge has not applied his judicial mind in that matter, and therefore in that case that cannot be called an adjudication. Now before adjudication, there must be a formal expression of that adjudication. What is formal adjudication? Formal adjudication means that decree must be drawn in the terms of the judgment. If a decree is not formally drawn in the terms of the judgment, no appeal lies from that judgment. Now, there are certain enactments under which applications are treated as suits or proceedings are treated as suits. For example, a proceeding under the Indian Succession Act, Hindu Marriage Act, Arbitration Act, under all these enactments, the applications are treated as suits and the final adjudication of all amounts to decree. Now, the next essential element is that there must be conclusive determination of the rights of the parties. What kind of rights? The substantive rights as well as procedural rights. Not mere procedural rights, but both substantive as well as procedural rights are required or are included under the definition of decree. The rights of the parties inter se relating to the jurisdiction, limitation, status, maintainability of suits, which have a general effect on the proceedings in a suit, are substantive rights. Therefore, where an order has been passed for dismissal of the suit for default of appearance of parties, that will not amount to a decree because no substantive determination of the rights of the parties has been done, and therefore in that case that does not amount to a decree. Now, with regard to all or any of the matters in controversy, that this all has to be done in the matter in controversy in the suit. Now, what is matter in controversy? Matter in controversy refers to the subject matter of the suit, in reference to which some relief is sought by the parties. So again, what is matter in controversy? It is regarding the questions of jurisdiction, maintainability, status of the parties, character of the parties. All these questions are the matters in controversy in a suit. However, if there is any interlocutory order with regard to the matters of procedure, which do not determine the substantive rights of the parties, in that case we cannot say that that is a decree. Now, when does a decree becomes a nullity? If a court having no inherent jurisdiction passes a decree, that decree is a nullity. However, if a court erroneously passed a decree, or if there is any error in the procedure adopted by the court in passing of a decree, that does not amount to, or that decree cannot be called a nullity. According to Section 2, Subclause 2, decree are of three kinds: preliminary, final, partly preliminary and partly final, which is also called composite decree. And there are certain deemed decrees which includes rejection of a plaint and a question which has been determined under Section 144, which is regarding the restitution of the parties, that the benefit has been claimed by the parties and the returning of that benefit to the other party, which has been dealt under Section 144. There are certain orders which are not included under the definition of decree, which are an adjudication from which an appeal lies as an appeal from an order, that is order 43, and an order for dismissal for default of appearance of the parties or for whatever default it may be. Now, what is preliminary decree and what is a final decree? A preliminary decree is a decree where further proceedings have to be taken in a suit before the final disposal of the suit. So, where a decree conclusively determines the rights of the parties with regard to all or any of the matters in the controversy in the suit, but does not completely disposes of the suit, that would amount to a preliminary decree. What is final decree? It is a step next to the preliminary decree. So, preliminary decree makes out or works out the rights, and final decree finally adjudicate the matter. A preliminary decree ascertains what is to be done. Final decree states the results which have been received by way of preliminary decree. A preliminary decree is not dependent upon a final decree. However, a final decree is dependent upon preliminary decree and is subordinate to preliminary decree. However, after the passing of a final decree, the preliminary decree does not extinguishes. Now, understanding this with the help of an example, let's suppose there is a partition suit. So, preliminary decree declares the rights of the parties. And what final decree will do? It will divide the property specifically by the principle of metes and bounds as per the rights which has been already declared by way of preliminary decree, and therefore the suit will completely disposed of. And after that, an executable decree will be made by the court. Now, preliminary decree can be granted in certain matters of preemption, in preemption suits, in dissolution of partnerships suits, in suits for possession and means profits, and in suits for partition. So in all the cases, although there is no bar that the court cannot grant preliminary decree in other cases, the court can grant preliminary decree even in the cases not covered by the provisions of the code. Now, the last kind of decree, which is composite decree. So composite decree is partly preliminary and partly final. Understanding this with the help of an example, let's suppose there is a suit for possession and means profit. So in that case, if the court grants the possession of the land in favor of the plaintiff and directs an inquiry in regard to the means profit, that would amount to a composite decree. So that was all with regard to the term decree that we have discussed in today's video in the light of Code of Civil Procedure. Hope you liked the video. Thank you very much.